Say it's Friday afternoon and productivity is tanking. One of your employees has missed deadlines, ignored protocols, and created chaos in your customer pipeline. You know it's time to make a change, but one wrong word, one missing form, and your business could face a wrongful termination lawsuit that drags on for months and costs you 5 figures before it even hits trial. I'm Santiago Cueto, a board-certified international business attorney based in Florida, and I've guided business owners through high-stakes termination for nearly 30 years. Today I'm giving you a bulletproof roadmap for how to fire an employee in Florida legally, ethically, and without burning down your business. Here's step 1. Know Florida's at-will reality, but don't get comfortable. Florida is an at-will employment state, meaning you can terminate an employee at any time for any reason or no reason at all, as long as it's not discriminatory or retaliatory. But here's the catch. Juries don't like no reason. Give one and make it legitimate. One that protects you from claims based on race, age, gender, disability, pregnancy, or whistleblowing. A best practice? Tie the termination to objective criteria. Job performance, violation of company policy, or repeated absenteeism. Put it in writing. Step 2, document everything before the exit. If it's not written, it didn't happen. Florida courts consistently favor employers who can show progressive discipline. Written warnings, performance improvement plans, evaluations, and emails showing clear expectations. Keep a timeline of events. If the employee ever claims, "I didn't know," your file should tell another story, one that a judge or jury can believe. Step 3, avoid constructive discharge traps. Be careful not to create a work environment that forces someone to quit. That's called constructive discharge, and in Florida, it's grounds for legal action. Don't cut hours, isolate the employee, or pile on unrealistic workloads hoping they'll resign on their own. That can backfire in court and turn into a retaliation case. Step 4, prepare a clean termination meeting. Don't wing it. Schedule the termination meeting in a private, professional setting. Bring a witness, ideally someone from HR or management. Keep the message short and direct. We've reviewed your performance over the 60 days, and unfortunately, it hasn't met the company's standards. Today will be your last day of employment. Avoid personal critiques, arguments, or apologies. Provide a termination letter with the reason, final pay, and information about COBRA or benefits continuation. Step 5, final paycheck and property return. Florida law doesn't require immediate payment on termination, but best practice is to issue the final paycheck on the last day. If the employee owes company property, laptops, badges, tools, document the return or deduct apportionately if allowed in your policy. Don't forget to revoke access to email, company software, and building access before or immediately after the meeting. This is where internal coordination with IT really matters. And step 6, consider a separation agreement when it's worth it. For high-level employees or sensitive departures, consider a separation agreement. This is a mutual release. The employee waives the right to sue, and in return, you may offer severance pay or extended benefits. But these agreements must carefully be drafted to comply with Florida law, and if age is a factor, with federal laws like the Older Workers Benefit Protection Act. Consult legal counsel before using one. Firing someone is never easy, but it doesn't have to become a courtroom drama. Stay within the law, lead with documentation, protect your company's reputation, and always treat people with respect. When done right, termination isn't the end of the story. It's a step forward, protecting your business, your culture, and your future. If this gave you clarity on how to fire the right way in Florida, hit that like button, subscribe for more legal tactics every Florida business owner should know.